Okay, let's start with the antecedents now. So we just want to know what uh, what is the New City Builders and who Mr. Minsola is. Now let's start with the New City Builders Incorporated, or the New City. It is a corporation duly organized under the law of the Philippines, engaged in construction business, specializing in structural and design works. On December 16, 2008, New hired Mr. Minsola as a laborer for the structural phase of its Avida 3 tower, or the Avida 3. Mr. Minsola was given a salary of 260 pesos per day. The employment contract stated that the duration of Mr. Minsola employment will last until the completion of the structural phase. On August 24, 2009, the structural phase of the Avida 3 was completed. Thus, Mr. Minsola received a notice of termination which stated at his employment shall be effectively terminated at the end of the working hour at 5 p.m. on the given date. And August 25, 2009, New hired Mr. Minsola as a mason for the structural phase of the Avida 3. December 2009, reviewing Mr. Minsola employment record, New City noticed that Mr. Minsola had no appointment paper as the mason for the structural phase. Consequently, New City instructed Mr. Minsola to update his employment record. However, the latter ignored New City's instruction and continued to work without appointment paper. On January 20, 2010, Mr. Minsola was again summoned to the office of the New City to sign his appointment paper. Mr. Minsola adamantly refused to comply with the directive. He stormed out of the office and never reported back to work. Now, on January 26, 2010, Mr. Minsola filed a complaint for various things like illegal dismissal, underpayment of salary, non-payment of 13-month pay, separation pay, refund of cash band in his position paper. Mr. Minsola claimed that he was also a regular employee of New City as he rendered work more than 1 year. And at this work as a laborer or mason and indesirable to the former's business claim that was constructively dismissed by New City. Alright, so on our readings right now, New City Builders is a corporation that is organized under the law of the Philippines on the construction business. It's specialized on structural and design works. Now, they have this employee, Mr. Minsola, which was hired during 2016. We have to look on this part right now, the things that are important, that matters on this case. Now, Mr. Minsola is a laborer of Avida 3 Tower Project. He is a project contracted employee. That the duration of his employment will last until the completion of the structural phase. Now, on August 24, 2009, the construction was completed. And as per the contract states, that the employment will be effective terminated at the end of working hour at 5 p.m. on the even date. Now see, on August 24, it states there that the contract is already terminated because the project has already been completed. Now, on August 25, Mr. Minsola was rehired by the New City on a different position, which is now a mason. But it is still the same project. It's still under the Avida 3, but on a different phase. It is now the architectural phase. Now, on December 2009, right after few months of his rehiring, the new city has reviewed Mr. Minsola's records, and they noticed that there were no appointment paper or whatsoever as a mason for the architectural phase. Consequently, New City has instructed Mr. Minsola to update his employment record. However, the latter or Mr. Minsola has ignored New City instruction, and he continuously worked without the appointment paper. Now, on January 20, 2010, a month later, Mr. Minsola is again summoned to the office of New City to sign his appointment paper. Mr. Minsola refused to comply with the directive. Instead, he stormed out of the office and never reported back for work. See, on January 26, 6 days after, Mr. Minsola filed a case. The ground that he filed are illegal dismissal, underpayment of salary, non-payment of the 13-month pay, separation pay, and refund of cash bond in his position paper. Now, Mr. Minsola claimed that he was a regular employee of New City as he rendered work for more than 1 year. And at his work as a laborer / mason, because he came from a laborer and then he rehired a day after and now as a mason, is a necessary and desirable in the former's business. Yes, we can say this is really desirable because this is a construction company, right? So he claimed that he was constructively dismissed by the New City. Now, let's see what does the labor arbiter has rendered on his decision. Now, on October 8, 2010, after a few months, the LA or the labor arbiter has dismissed the case of Mr. Minsola. The reason is lack of merit. Now, why? What is lack of merit? Now, let's read what they say. The LA found that Mr. Minsola was a project employee who was hired for a specific project by New City. The fact that Mr. Minsola worked for more than 1 year did not convert his employment status to regular. The LA stressed that the second paragraph of Article 280, which refers to the regularization of the employee who rendered services for more than 1 year, pertains to casual employee. So it's still not an irregular. Yes, as my experience during my work in the Philippines, mostly they say that we have to start as a contractual, then casual, until it became a permanent. But as I am not a lawyer, but that is only my personal opinion. Now, on LA opened that the Mr. Minsola was not terminated from work. The LA noted that the record are bereft of any proof of evidence showing that Mr. Minsola was actually terminated from work. Rather, it was actually Mr. Minsola who suddenly stopped reporting after he was instructed to sign and update his employment record. The LA ordered Mr. Minsola reinstatement until the completion of the project. Now, Mr. Minsola's monetary claim, the LA awarded 2,600 pesos, 2,652 pesos as the 13-month pay differential. Okay, let's discuss about this one right now against the labor arbiter render decision. Now, dismissing the complaint of the illegal dismissal. Okay, so on the first part, it says the LA found Mr. Minsola was a project employee who was hired for a specific project by New Year City. The fact that Mr. Minsola worked for more than 1 year did not convert his employment status to regular. See, on the record, it states from the previous slides, it says here that Mr. Minsola was hired as a laborer for the structural phase of Avida 3 Tower project. The employment contract stated the duration of Mr. Minsola's employment will last until the completion of the structural phase. Now, if you're going back to the labor arbitrage, say, so as we for if we look only on the labor arbitrage's rendered decision, this could be reasonable because it states here that he was only hired for a specific project by the new city. The fact that he worked for more than a year is not a reason to convert his employment status to regular, because at first there is an actual contract stating that his work will be terminated or will end after the completion of the project, which was already finished during August 24 of 2009. Now, on August 25, he was rehired again. So, we could say it's a different contract, or it should be a different start again, because he has already completed the contract stated on his first hiring under the new city. Now, LA stressed that the second paragraph of Article 280, which refers to the regularization of the employee who rendered service more than 1 year, pertains to casual employees. So, as per the labor arbiter, it says on the paragraph of Article 280, the regularization will only affect on the casual employee, not on the project employees. Because there's a difference between a casual employee and a project employee. As the project employee will only end on his tenure when the project has already completed. Again, this is only my opinion. Now, the LA opened that Mr. Minsola was not terminated from work. Okay. Now, the LA noted that the record are bereft of any proof of evidence that showing that Mr. Minsola actually terminated from work. Rather, it was actually Mr. Minsola who suddenly stopped reporting after he was instructed to sign and update his employment record. Ordered Mr. Minsola reinstatement until the completion of the project. Going back to the antecedents, it states here, Mr. Minsola has no employment record until part of his reappointment or rehiring of August 25, 2009 until December of 2009. It states there that Mr. Minsola's employment record is not available. So, New City noticed that Mr. Minsola has no appointment paper as a mason of the architectural phase. Consequently, the New City instructed Mr. Minsola to update his employment record. Unfortunately, Mr. Minsola ignored the New City instruction and continued work without appointment paper. Now, on 1 month later, January 20, 2010, Mr. Minsola was again summoned to the office of New City to sign his appointment paper. Therefore, Mr. Minsola adamantly refused to comply with the directive. He stormed out of the office and never reported back to work. So, if you go back here on the ruling of the labor arbiter, there is a cause, in my opinion again, that the termination of Mr. Minsola is not accurate because Mr. Minsola has suddenly stopped reporting after he was instructed to sign and update his employment record. So, on Mr. Minsola's monetary claim, the LA awarded 2,652 pesos, 2,652 pesos as a 13-month pay differential. For me also, it could be, in my opinion, it could be awarded to Mr. Minsola because he worked more than a year. But if you go on, going back to his record, on my opinion, hence there is no record that he is re-employed again on the said company. There is no evidence that states that he is working more than a year. Anyway, that is my own opinion. But hence, Mr. Minsola was unhappy on the ruling. Mr. Minsola filed an appeal before the National Labor Relations Commission, or the NLRC. Now, let's see the ruling of the National Labor Relations Commission. Now, on April 29, 2011, the NLRC rendered a decision reversing the LA ruling. So, the NLRC found that Mr. Minsola is a regular employee and was constructively dismissed when he was made to sign a project employment contract, citing the case of Furnace v. NLRC. The NLRC concluded that Mr. Minsola became a regular employee when his services were continued beyond the original term of his project employment without the benefit of new contract fixing the duration of his employment. Now, this is where I have a question about, because NLRC concluded that Mr. Minsola became a regular employee when his services were continued beyond the original term of his employment without the benefit of the new contract fixing the duration of his employment. So, for me, there is a little bit of bias on this part. It's because the first contract states that his first employment will be terminated or will end after the first project has already been completed. So therefore, he has already completed his contract. Now, on the second part, as I have said previously, there was no document or whatsoever that stating that he was reinstated as a Mason. Therefore, the new city has asked Mr. Minsola to review his records on December of 2009. So, there is no continuation actually in record that states that he is been reinstated. There is no a fact, there is no documentation. It states that he is been working again with the new city. Yet, if a humanitarian point of view, yes, it's because the person has been working from 2008 to 2009 until 2010. So therefore, he has rendered his actual effort or work to the company. But as I have said, in my opinion, there is no hard constructive document stating that he is reinstated. Now, the NLRC noted that Mr. Minsola's job as a labor or mason was necessary and desirable to the usual business of the new city. Yes, that is correct. In my opinion, Mr. Minsola's job as a labor or mason was necessary and desirable to the usual business of New City. Why? Because it is a construction business. It is a structural and design business. Therefore, laborer and mason are core employees. They are desirable. They are necessary. Consequently, the NLRC ordered New City to reinstate Mensola and pay him full package from January 2010 until his actual reinstatement. In this part, as I have said, in my own opinion, I'm not being biased on my opinion, but as I can say, there is still no concrete or actual documentation stating that he was reinstated. There was no actual evidence saying that he is rehired until the day of Mr. Mensola was asked to update his documentation. Instead, as it was mentioned from the very beginning, it states here that Mr. Mensola, on December 2009, instructed Mr. Mensola to update his employment record. However, Mr. Mensola ignored New City's instruction and continued to work without the appointment paper. Still, it states here, he has no document stating that he is a worker of New City Construction. Again, as per Mr. Mensola monetary claims, the NLRC awarded the former his salary differential, service incentive, leave pay differential, and holiday pay. The NLRC observed that the prevailing minimum wage rate at the time of Mr. Mensola employment was 380 pesos, 82 pesos per day. This notwithstanding Mr. Mensola merely received a wage of 260 pesos per day. The NLRC awarded a salary differential of 41,660 pesos and 64 centavo and the service incentive leave pay differential of 300 pesos. 310 pesos actually. In addition, that NLRC ordered the imposition of 10% attorney fee to the total monetary award. Okay. In attorney fee and the total monetary award, yes, I could say yes, because it's Mr. Mensola who is trying to show that he is deprived of something. He is deprived of regularization. He was deprived of documentation. Yes, and hence he has no other income but from the New City. At least considerably, we have to impose at least 10% of attorney fee from the total monetary award. Yes. But as I have said, in my own opinion, on this part of NLRC's decision is a little bit of unbiased. Why? The evidence is not there. The document is not there. There's no constructive, there is no actual documentation, there's no hard material stating that Mr. Mensola was rehired. There is no actual documentation stating that Mr. Mensola has been working with them since August of 2009 until January of 2010. So since the NLRC ruling favors to Mr. Minsola, the new city is dissatisfied with the ruling. Therefore, the new city filed a motion for reconsideration, which was denied by the NLRC and its resolution. Unfortunately, we still have the certiorari resolution under the Rule 65 of the revised rules of court with the Court of Appeals. Let us see a little bit of what does the Rule 65 of revised rules of court says. Again, it states here on the rule number 65, certiorari, prohibition, and mandamus. On section 1 of the petition of for certiorari, when any tribunal, board, or officer exercising judicial or quasi-judicial function has acted without or in excess of his jurisdiction, or with grave abuse of discretion amounting the lack of excess of jurisdiction, and there is no appeal or any plain, speedy, or adequate remedy in the ordinary course of law, a person aggrieved thereby may file a verified petition in a proper court. Allegedly, the fact with certainty and praying that such judgment be rendered annulling or modifying the proceeding of such tribunal, board, or officer, and granting such incidental relief as law and justice may require. The petition shall be accompanied by the certified true copy of judgment, order, or resolution subject thereof, copies of all pleading and documents relevant and pertinent thereto, and sworn certification of non-forum shopping as provided on the third paragraph of section 3, rule 46. Now, again, as I have mentioned, on NLRC's decision on the case, there is a little bit of excess of its jurisdiction, or the rules, or let us say there are grounds that you can find that there is a little bit of one-sided or unbiased or biased, because the NLRC has ruled over the labor arbiters ruling without a proper documentation. So I might be saying yes, there is a reason for certiorari under Rule 65 of the revised rules of court with the CA. Now let's go to the ruling of the Court of Appeals. So on December 21 to 2012, the Court of Appeal reversed the NLRC decision. The Court of Appeal reasoned that Mr. Minsola was hired for specific phases in Aveda 3. He was originally hired as a laborer for the structural phase of the Aveda 3. Upon the completion of the structural phase, he was rehired in a different capacity as a mason for the architectural phase for the Aveda 3 construction. The CA observed that Mr. Minsola's tenure as a laborer was covered by an employment contract. This is what I'm saying. During the first decision of the labor arbiters, they follow what does the employment contract states. It states there again, and I have said again, that the employment of Mr. Minsola will end after the completion of the project, which is clearly provided that he was hired to work on a certain phase in the construction of Avida 3. And that his term of employment will not extend beyond the completion of the same project. The say observed that the records are bereft of any proof that showing that Minsola has constructively dismissed by the new city. So, there was really no hard evidence. As we say, hard evidence stating that Mr. Minsola was dismissed improperly. So, regarding the monetary award, still the CA reinstated the labor arbiter's ruling, thereby ordering the payment of 2,652 pesos as a 13th-month pay differential. Now, on June 11, 2013, Mr. Minsola again filed a motion of reconsideration which was denied by the CA in its resolution. And yet, Mr. Minsola still undeterred and he proceed with his petition. And now he uses the certiorari under the Rule 45 of the revised Rules of Court, seeking for the reversal of the asyled CA decision and resolution. So what does Rule 45 says? Decision of final orders or resolution of the Court of Appeal in any case, regardless of the nature of the action or proceeding involved, may be appealed to the Supreme Court by filing petition for review, which would be but a continuation of the appellate process over the original case. Therefore, it does not say that the higher or the Supreme Court has to revise or modify or change what was the decision made. Instead, they have to continuously review the petition. Filing petition for review, they only wanted to review and to find out if there is really something that needs to be changed. Now, let's see the ruling of the court. Now, the issues, let's go back to the issue. Now, the instant legal conundrum rests on the following issues to it. Whether or not Mr. Minsola was a project employee, whether or not Mr. Minsola was a constructive dismissed by New City, whether or not Mr. Minsola is entitled to his monetary claim consisting of his salary differential, service incentive leave pay differential, holiday pay, and 10% of attorney's fee. Mr. Minsola claims that he is a regular employee, as his work as a laborer or mason was necessary and desirable to the New City's construction business. Yes, as he has said again, the work is necessary and desirable. Mr. Minsola point out that he worked for a New City for more than 1 year, more particularly for 13 months, thereby automatically bestowing upon him regular employment status. Although he was initially hired as a laborer, his employment in Avida 3 continued when he was rehired as a mason without the execution of another contract. So it was mentioned here, without the execution of the contract fixing the term of his employment. Mr. Minsola further asserts that the New City Act of forcing him to sign an employment contract is a scheme to preclude him of acquiring permanent employment status. In addition, Mr. Minsola seeks for the payment of his salary differential, 13-month pay differential, service incentive leave pay differential, and holiday pay for the attorney fee. He asserts that he received a meager daily wage of 260 pesos, which was far below the prevailing minimum wage of 382 per day. As such, he is entitled to receive differential for his salary, 13-month pay, and service incentive leave pay. Minsola claimed that the New City failed to present proof showing that he was given his holiday pay. Lastly, Minsola asserts that he is entitled to an award of attorney fee, and he was forced to litigate and defend his right against the illegal dismissal of unlawful withholding of his wages. On the other hand, the New City counters Mr. Minsola's filing case because as per UCT, he was hired as a project employee to work for the structural phase and thereafter the actual phase of the Aveda 3. His work as a laborer was completely different from the task as a mason. In this regards, his subsequent rehiring cannot be construed as a continuation of his former employment. That is correct. The simple fact that his employment has gone beyond 1 year does not automatically convert his employment status. And lastly, UCT maintains that Mr. Minsola failed to present any proof of substantiate his claim of illegal dismissal. It did not dismiss Minsola, nor did not prevent any latter from reporting to work. Okay, now on this part, let's check everything that was filed by Mr. Minsola. Okay, now as I have said, in my opinion, that is only my opinion. That was only my opinion. In the case at bar, Mr. Minsola was hired by New City Builders to perform work for 2 different phases in the construction of Aveda 3. So, the record shows that he was hired as a laborer for the structural phase of Aveda 3 from December 16 to August 24, 2009. Upon the completion of the structural phase, he was again employed from August 25 by the New City, this time for the architectural phase of the same project. Unfortunately, there is still no record. It states that he was rehired because, as stated, he was asked to review his records. There is no quibbling that Mr. Minsola was adequately informed by his employment status as a project employee at the time of his engagement. Yes, there is a hard evidence copy stating that he is a project employment. This is clearly substantiate that the latter's employment contract stating that he was hired as a project employee. His employment was the indicated stating dates therein and will end on the completion of the project. So, there is a proof that he was just a project employee. The notice regarding the term of his employment, Minsola avers that his continuous work as a laborer and mason, coupled with the fact that he performed tasks necessary and vital to the New City business, made him regular employee to the letter. Yes, as I have said again. Wait. Now, as I have said, yes, the job of Mr. Minsola is very much desirable and it's very much necessary on the business because he is a mason and he is also a laborer. Therefore, it is really needed, but it does not give a great deal to say that he will become a regular on this part. Why? According to it is not uncommon for the construction firm to hire a project employees to perform work necessary and vital to its business. The court also acknowledged that the unique characteristic of a construction business or industry emphasized that the laborer's performance of work that is necessary and vital to employer's construction business and the former's repeated rehiring do not automatically lead for regularization. Why? It's because construction business also works in projects. This is not a continuous recurrent business because it only works upon a specific project. You cannot impose a person's regularity on this kind of industry because the business will not stand a long term of giving salary or incentives to an employee without any projects. That is again my opinion. Minsola was not constructively dismissed by New City. Minsola contends that the New City constructively dismissed him when he was allegedly forced to sign an employment contract, termination report, and other documents. The court is not persuaded. Yes. In the labor's laws, constructive dismissal is also known as dismissal in disguise. It is where there is a cessation of work because continued employment is rendered impossible, unreasonable, or unlikely as an offer involving a demotion in rank or any diminution in pay and other benefits. There must be an act of amounting of dismissal, but made to appear as if it were not. It may likewise exist if an act of clear discrimination, insensibility, or disdain by the employers become so unbearable on the part of the employee that it could foreclose any choice by him except to forego his continued employment. In this case at bar, Minsola failed to advert to any particular act showing that he was actually dismissed or terminated from his employment. Neither did he allege that his continued employment with New City was rendered impossible, unreasonable, or unlikely, nor was he demoted, nor made to suffer from any act of discrimination or disdain. Neither was there any single allegation that he was prevented or barred from returning to work. Contrary, it was actually Mr. Minsola who stormed out of the New City office and refused to report to work. It cannot be gainsaid that there is no illegal dismissal to speak of where the employee was not notified and he had been dismissed from employment, nor he was prevented from returning to work. Yes. As the statement from the very beginning, from the antecedents, it says here that Mr. Minsola was only asked to come and check his record, review his record, and sign the document because he has no record. Unfortunately, Mr. Minsola was the one who briefed and he went out from the office. So it does not say that there is a proof saying that he was really illegally terminated. So lastly, let's talk about the monetary claims. This is the one of the most controversial part on this subject that I might look into. That's why I have not much talk about this from the very beginning, because there is a tiny thing that I found on this part where I could say New City failed to present the proper documentation. Therefore, the company or the New City has to pay the monetary that is rightful to Mr. Minsola. Let's read this one. Minsola is entitled to salary differential, 13-month pay differential, and service incentive, leave pay differential, holiday pay, and attorney fee. Notably, in determining the employee's entitlement to monetary claims, the burden of proof is shifted from the employer to the employee, depending on the monetary claim sought. In claims of payment of salary differential, service incentive leave, holiday pay, and 13-month pay, the burden rests on the employer to prove the payment. Yes, the fact that all pertinent personal files, payrolls, records, remittances, and other similar documents which will show that the differential, service incentive, leave, and other claims of workers have been paid are all positioned and controlled by the employer. All the record, all the documentations, all the hard copies of proof of payment of all this are under the position of and control of the employer, where therefore New City has to prove that they have paid properly, that they have given all the salary, the incentives that should be given to the person. For overtime pay, premium pays, or holidays or rest day, the burden is shifted now to the employee, as these monetary claims are not incurred in the normal course of businesses. As these monetary claims are not incurred in the normal course of business, it is thus incumbent upon the employee to first prove that he actually rendered the services in excess of the regular 8 working hours a day, that he in fact worked on holidays and rest days. Yes. Now, in regards to overtime, rest day, holiday, and premium pays, the employee has to prove first whether he has rendered his services more than a regular hours of 8 in a day, why he made an excess of hours, why is it needed that he has to work more than 8 hours, and why it is important that he has to get all those hours. All this should be provided and should be proved by the employee. In this case, the record showed that Mr. Mensola was given a daily wage of 260. Now, this is the thing that I've been trying to say a while ago, that a single statement that was not written in the contract could fall into a big monetary issue or challenge from the employer. Again, in this case, the record shows that Mr. Mensola was given a daily wage of 260 pesos, as shown in his employment contract dated December 2016 of 2008. It must be noted that this amount falls below the prevailing minimum wage of 382. Now, if a contract was stated that he has to pay only 260 pesos, it should be also included the statement that it is below the differential amount, the minimum wage of 382. Why? This is transparency. People should know what was the shortage, or the employee should know what is the shortage of the pay that they are receiving, why they have a short amount of pay, and they should agree and accept the fact that they will receive on such amount. They have their approval, and it should be stated in a document. It should be stated in a contract. This is what makes me seeing that the New City construction company failed in their effort of providing the exact information to the employee. Clearly, Mr. Mensola is entitled to salary differential from December 16 to January 19, amounting 41,616 and 64 pesos. Ouch. That is because of the simple word not stated in the contract that the wage that the Mr. Minsola is receiving is below the minimum wage. The amount service incentive leave pay he received on December 19 was only 1,600 instead of 1,900. He is also entitled of 13-month pay of 2,652. Moreover, Mr. Minsola is entitled to holiday pay of 5,340 for 2 work legal holidays on December, 11 unworked legal holidays on 2009, and 1 legal holiday on January of 2010. New City failed to present the payrolls that would show that Minsola's salary was inclusive of holiday pay. On the other hand, Mr. Minsola claimed to premium pay for holiday, rest day, and well-night shift differential pay are denied of lack of actual basis. Again, on the above statement says that for overtime pay, premium pays, and holiday pay, it is under the burden of the employee to prove the importance of making such claim. Finally, Mr. Minsola likewise be awarded with attorney fee as an instant case included in claim and unlawful wage-held wages. So this is our topic from the Supreme Court, a case from Mr. Raymond J. Minsola, the petitioner, to New City Builders Incorporated, and Engineer Ernel Fajardo, the respondent. The case number is 207613.